Welcome to Non-Obviousness with you Hansen.
Yes, that's it. Thank you. So we are very fortunate today to have Patricia A. Martone with us, who has fantastic experience on from almost the beginning of time for patent lawyers. I mean, it's the interesting enough. Pat and I basically started out at the same time. Um, And one of the things is when I was a first year student at Georgetown, we had 150 in three different sections, and that was it. There were no small classes or anything else. There were three women in my class. By the time I graduated, I think it was 15 to 20%, and then shortly it really pumped up. And now, basically, every year there are more women graduates or students in law school than men. But you were a pioneer in a interesting time, and not only a pioneer in the law, but a pioneer in patent law, which is even like pioneer squared. But let's start out first of all. Where were you born,
I was born in Brooklyn, New York,
and how long did you live in Brooklyn?
for 4 years.
And then what did you do?
My family moved to Staten Island,
And where in Staten Island?
in Port Richmond, which is on the North Shore of Staten Island.
I was born in Staten Island, and 4 years, and moved out to Long Island. I don't remember those well, but it was a nice, almost suburban experience when I was there. I don't know about with regard to
It
you.
was almost a rural experience in some parts of Staten Island, not where I was, but yes, it was very, quiet, small town. It had maybe 250,000 residents in the whole borough, and it was a very nice place to grow up.
All right, so you were there through high school,
Yes,
and then you went to college. Where'd you go to college?
I went to college at Washington Square at NYU.
And how did you like that?
It was a big change, but I love being in the city, and of course it was the 1960s, and it was very tumultuous time towards the end of when I graduated, which was 1968. But I enjoyed the city. I studied chemistry, but I also took a lot of liberal arts courses, particularly in history. So I felt that I had a good education there.
Yeah, well, NYU even then had a fantastic reputation. Actually, I got accepted to NYU and Georgetown, and I knew NYU was probably a better school, but I had these ideas that maybe wanted to do something with government, and if I was in Washington, it might help. And actually, it was in that regard. And I also thought Georgetown was a great experience. So we both enjoyed our law school experiences. And then your first job was what?
I went to college,
Oh,
then I went to graduate school for a year, then I worked for a year, then I went to law school
okay. Where'd you go to graduate school?
at Johns Hopkins,
Oh, and what were you doing at John Hopkins?
studying physical chemistry.
Oh. And then you decided enough of all this technical stuff. I'm going to be a lawyer.
Right.
And then where did you go to law school?
I went to NYU.
Okay. And how was that experience?
Yeah. Well, I loved every minute of it. Actually, I really felt like I had found, the right profession, and it took a while to convert from being a scientist to being a lawyer. But after a few months, I think I got into it.
I have found actually that one of the problems, and obviously you've never had this, but one of the problems with strong science background going into the law is they tend to look at doctrine like the law of gravity, and you can't question the law of gravity. It's just a law you apply.
Right.
And I'm a legal realist, so I'm actually on the other thing is that basically you're all time not paying that much attention to the doctrine as opposed to the facts and other stuff. Um, but you seem not to have ever fallen into that trap. And so well, tell us a bit. I know you had this very much a background where you found mentors very important. And how do you get a mentor then? Was it just natural? They just showed up for everybody? Or you had to seek them out? Or how did it happen?
My first, legal job out of law school was at Kelly Dry at Warren, where was assigned to the litigation department. The real mentors, I think, came when I went to Fish and Eve a few years later, and I think that some people are just naturally good at mentoring. Now there are all kinds of different, programs to promote mentoring in law firms, and starts in law school, and mentoring is important. But I think that you find someone for a young lawyer at that time. You found someone that you like to work with, and they like to work with you, and you learn from them.
So, someone coming out, just for people who are listening to this who are now law students, you would say mentoring is still very important. And what could they do going into a law firm to help make that happen? Is it subtle? Is it you go speak to someone, or what do you do?
Well, I think it depends on the organization of the firm. But for example, when I was a partner of Ropes and Gray, which was very serious about mentoring and other things, is that there was a central person who assigned associates to cases. And when you needed an associate on a case, you could talk to them, and they would tell you sometimes that a particular uh, associate asked to work with you or wanted to work on a particular subject matter that was like yours. I mean, I think there's multiple kinds of mentoring, which has been uh, described in recent years. I think the first is, and foremost, is actually working with someone and giving them work to do. Others are just being a sounding board. I mean, these days, I think in law firms, there are programs where you can become associated with a particular partner who will offer you advice. I think there are just a lot of different ways to do it, but I think it's always good to be proactive and not wait for someone to do this. When I started in the 1970s, basically there wasn't very much. Young lawyers couldn't really be so proactive. We kind of waited for people to were asked to work with us. But I think nowadays people have to be proactive. But there's a lot of training going on. I just went to a New York State Bar Association program about mentoring, from a diversity perspective and how to bring different people along. And I think I've always said that as a partner, when you want to assign someone to work on a case and you feel that you're going to get client pushback because, for example, the person may not be experienced enough, you have to advocate to the clients and explain to them why it's good for them that this person is working on this case. And I think that that's very important, that we manage the relationships with our clients so they understand not that we're doing a favor to someone, but this person is really good and should be working on their case and will do a good job. And I have to say, every time I did that, it worked out because the lawyer did do a good job.
Okay, so when we went into law firms, it was basically lockstep to a large extent of where your office was, what you paid, and even partners were this step and this step. Everyone just dealt with the law. You didn't have to worry about getting clients. There were some rainmakers, but institutional clients and law firms have been together for years. So one was able, for instance, I was taking along to watch depositions, or I would hold the documents or something. Today, the economics are such that there's almost an incentive to keep the young lawyers in the office producing something or other rather than going out, or am I wrong?
I think, unfortunately, that's true because some clients are particularly adverse to working with associates now. But basically, I think that, once again, you can't bill for all the training that you do. I mean, that should be built into this into law firm economics, because otherwise, in 10 or 20 years, we're not going to have very many good lawyers. The pool is decreasing if we don't train our associates.
Well, I think one of the things is associates are pricing themselves out of well, not pricing themselves out, someone else is doing. This starting salaries are such that it makes it more difficult to use them and bring them along. And it's almost like you have to have them producing immediately to justify their high salaries. So the high salaries sound good, but it may actually be reducing the quality of the experience the associate's getting.
Well, actually, I don't think it's their salary that's the problem. I think it's the combination of the billing rate and the push in firms to bill every second that anyone works. And I think that you really realistically can't do that and train people adequately.
Okay. All right. Patent law. We're going to go back, actually, if we have time, I'm hopefully your experience in the beginning. By the way, with this, we're going to put a link to Pat's great article, Reflections on One Woman's Legal Career and the Critical Role of Mentors, in the NYIPLA Bulletin. So you'll be able to read this thing for yourself, and I think it's absolutely fascinating. She also has written an article on the decline of the patent system, which is in the Mitchell, Hamlin, and Law Review, and we'll put the link to that as well. Okay, so patent law. What are the differences in doing patent law in a firm as opposed to every other aspect, if there are?
I think that that it's much like any very complex piece of litigation. I personally think it's important to have lawyers on the case with a technical background. Not everyone agrees with me, but I think that while in every type of case there's a particular approach that works well for patent cases, for any complex case, you need to break it down and make it as simple as possible. And so I think in that sense, it's not different from other very complex litigation. Interestingly, when I was at Fish and Eve, which was a specialty firm and that it specialized in intellectual property.
An IP boutique, as
Yes.
it's called.
I did a lot of trademark litigation and some copyright litigation, particularly the NBA versus Motorola case. I did not limit myself to patents. Didn't really see any difference in trying those types of cases. I do think that there is a substantive body of patent law that people really need to know, and I think that's not always true that they know it based on what I've seen. And secondly, you unless you have a lot of expensive experts, you really do need to have at least some lawyers on the case be either have a technical background or be very fluent in understanding technology.
Well, I know litigators who say, I could litigate anything. Litigation is litigation. There's certain skills, what you have to do, how you have to present this or this. Is that equally true in patents?
Well, I know that people say that. I'm a little skeptical about that. I think that they would then say that I could rely on experts, but experts are expensive. I mean, you have to. I mean, experts cost as much as lawyers do, and the pressure from clients to have a very streamlined case and charge as little as possible makes it difficult to use experts in that role, I believe.
So if you had a choice between regular lawyers being on the case and lawyers knowing patents, but when it comes to discussing the thing with the jury, you have the regular lawyers do it. Maybe when you have the examination on a trial of an expert or others, you have the lawyers with the knowledge. Is it necessary to do that? I mean, one thing, and a number of people said that, including Chief Judge of the Court of Appeals of the Federal Circuit, is people with strong technical background have trouble bringing it down to the level of the regular person in the street. And that's very important, obviously, in litigation, and it is important. So, how do you have a mix? I mean, I constantly tell students, or even when I'm out, everyone use acronyms, this, the shorthand. And the more you know, the more you're going to have 3 words mean a paragraph, which is a disaster if you're trying to influence a judge who doesn't know it or a jury doesn't know it. So just the whole idea is you have to go back to square one. How did you actually learn this? And then what do you have to tell these people to actually get them to understand it is always important, but particularly important in cases with technology. What do you think?
Well, it is, but at Fish and Eve, we were trained to be trial lawyers as well as patent lawyers, and it's possible to be trained as both. And it was drummed into us from when we were first, junior associates that we needed to learn how to explain technology in a simple way. Nowadays, we would. I mean, that also affects your choice of an expert. Some experts are a lot better explaining things simply than other experts are. And of course, now we do jury research and even research and hire jury consultants for even cases not before a jury, as you try to work it so that you get the technical issues down in a very simple way that you can explain them. I believe the same person can be both. If you don't have this same person who can be both, then you do need 2 people. And I think that trial expertise is hard to come by these days, which is creating a bigger role for more general trial lawyers because they probably have more trial experience.
All right. So, what exactly you were with 2 or 3 law firms,
Right.
very good law firms, and now you're on your own, I
Right.
guess. And what exactly are you doing now in terms of being a lawyer?
Okay. Well, most of my work since I've been doing this for 6 years has been sometimes I am a second pair of eyes in a litigation. I'm not on the papers, but I review papers and make suggestions. I've done some negotiations of patent sales and agreements. I don't want to go to court at this stage of my career, but basically, I've done a lot of advice about for claims, possible claims against the company, possible working up potential patent litigation, helping clients who don't have a an internal structure to support the IP of their company, develop one. I've done a lot of different things. I mean, right now, my focus really is moving more towards serving as an arbitrator in cases because I think that I've had a lot of litigation experience and I think I could be very helpful in simplifying disputes.
All right. And how do you get business as an arbitrator?
Well, that's a good question, which I'm still learning about. But basically, first you need to be trained as an arbitrator.
And how do you get trained as
Trained.
an arbitrator?
One way is through the AAA, the American Arbitration Association. You have to apply to be part of a panel. Then you go to a training session that lasts for several days, and then you take yearly CLE courses, and you promote your practice like you would promote any other practice. You can also do expedited, smaller arbitrations to get started. I've also done some pro bono work for students, serving as an arbitrator in student arbitration exercises. So it's not that much different than starting another kind of practice, but you really have to be qualified. And so I'm on the AAA commercial panel of arbitrators, and I'm also on the AIPLA's list of arbitrators and mediators.
All right, so the whole world, you should think about Pat. Now, is this single arbitration? Is it 3 people? Which is it, or is it both?
It's well, it can be either, but I think the general practice is more for complex cases is 3 independent arbitrators.
All right. Now, I don't know that much about it, but from a little I know from the past, it it used to be one side picks an arbitrator and the other side picks an arbitrator, and those two people pick the third one. Is that still what happens?
That sometimes, but I think that the trend now, and what the AAA recommends is to have three independent uh, arbitrators. I guess in other words, the parties select them, and you don't have party arbitrators. You really have three independent
All right.
arbitrators.
So I'm a, I'm out there as a litigator,
Right.
and I want to arbitrate. What do I get? 5,000 names, and I pick one, or how does it work?
Well, you go to an organization like the AAA, and you can suggest names to them, or you can ask them to suggest names. But then the parties are given a relatively short list of potential arbitrators who are then asked if they have any conflicts, and then they go into the selection process. And the arbitrator, to be, never really knows very much about this except until they're asked about their specific conflict issues, because it's done by staff to keep the arbitrators to be neutral.
Okay. Now, you find that actually people, especially, let's say in patents, that there's a tendency for people to have a strong view about maybe the protection of patents, or a view that was skeptical of protection of patents, and this is something you have to take into account when you pick an arbitrator.
I suspect that parties will look at the backgrounds of arbitrators and what they've written and spoken about, but it's not clear to me that you'll really ever figure that out, because arbitrators have said that they're going to decide things independently and without bias, and I think people really mean that. So I think that what people are frequently looking for in arbitrators is in the patent field technical backgrounds, and that's true for patent license disputes, where I think there's even more of a role for patents for arbitration. I think they're looking at technical backgrounds, experience, including in arbitration and litigation. I think that's what they're principally looking at, but they will, I'm sure, read the writings of arbitrators.
Okay, so I'm out there and I have a controversy with another party. At what point do I say, yeah, we're going to litigate, or at what point do I say, no, maybe we arbitrate? Is it arbitration now more in the beginning, or is it because thinking about litigation doesn't seem to work?
It depends on the agreement between the parties. Uh, ar- this the progress of arbitration is largely dominated by what the parties have agreed to, and so in an agreement, if there's a pre-existing agreement, the parties may agree not to litigate and arbitrate instead. They may have agreed to arbitrate uh, before they do litigation, or they may have agreed to arbitrate certain issues and not other issues. So it really, first you would have to look at any existing agreement between the parties. If they have no agreement, then they get together, and that's then the process of the arbitration is something. They go to an organization like AAA, and they say what they want to do. And part of the preliminary hearing with the parties is to flesh out a lot of these details that may not be in any agreement.
Okay, so your advice to the outside world is arbitration is better if XYZ, and litigation is better than XYZ, or is it, when should the people start? Now, obviously, if you have an agreement that already has arbitration in it, fine.
Right.
But I'm talking about a dispute, and it may actually be no one agreed to it, but now both sides, I mean, one side thinks maybe we can arbitrate. How often should one side raise that earlier in a litigation, do you think?
Well, first of all, in current district court litigation, mediation is required. and in different courts at different stages of the agreement, of the I should say of the litigation. So you may go to a mediation, and the parties may, working with a mediator, which is sometimes a judge or an experienced a mediator, can decide that they want arbitration, or maybe they want the preliminary evaluation of a neutral, which is different because it's not binding. I mean, all these things can be fashioned, but some kind of ADR is absolutely required in every litigation.
Okay. All right. Now, you have said that having a global perspective is important to patent lawyers. What do you mean by that?
Well, because I think that our clients, have global perspectives. I've represented a lot of also companies from other countries, particularly in Japan and in Europe. But even our U.S. clients have a global perspective. So in terms of whether one should institute litigation, for example, I think it's important for our clients to look at the prospect of litigating somewhere other than the United States, given some of the problems in our system now. I think it's important to be able to work with our clients in structuring perhaps filing in the United States and several other countries at the same time. I just think that the idea to look at that is very important. The other thing that I think is important is that in understanding litigation involving parties who are not located in the United States, it's it's a good idea to understand sort of how their own system works, because it affects their conduct in litigation and their ability to understand. Particularly, I can say with respect to working closely with Japanese clients, where I was fortunate frequently to have either a bengoshi who was in a party part of who was part of it to to bridge the legal cultures.
What's a bengoshi?
It's a Japanese litigating lawyer,
Okay.
and in those cases, the clients, were principally knowledgeable about Japanese law. So if you want to explain American law to them and they didn't understand you, it might be because there's some snag about Japanese law that's different and you don't know that. So it's important to at least get some general understanding of that. And I just think the world is a global place these days, and business is global, and it's important to be on top of that.
Okay. Do you find that things which we accept as well, first of all, the United States is unique in the sense of the way our law developed. We got the whole common law thing from Britain, but we then really expanded that to where almost a lot of our law is judge made, and even today now, even though there's a statute, a lot of it is judge made. That idea that the judges, almost, if you think about almost every major doctrine, at least in trademarks or copyright, a lot of them were court created. I can't speak to patents, but whereas the civil law systems, the judge has a more minor role. Do you think that's true, and do you think that is somehow a problem or has to be taken into account if you're going to be global with your litigation?
Well, certainly the legal standards in different countries are different, and there is a big difference between the common law and the civil law. And that's part of the difficulty of global litigation, is that you can't predict the same outcome in every country based on the same position, because the law is different. I would say that in my experience in code countries, that the
Code countries is civil law?
law, yes, that they are in civil law countries, that there is not the role of precedent that we have in the United States, and it causes the lawyers from those countries, when they read our cases, to look for some statement of the court and think that's like binding precedent, for every case. And so that's why I think if you're doing global litigation, you need very good lawyers in each country, even if the client needs them and you want them because you want to be able to talk with them about how what's going on in your country is going to affect their country and vice versa.
Okay. What drew you into patent law as opposed to all the other areas of law?
Well, I have a bachelor's and master's degree in chemistry, and when I went to law school, I was not necessarily thinking about being a patent lawyer. I thought about trial work. Actually, thought about being a criminal lawyer for a time, but when I got out of into the practice of law at Kelly Dry, after 2 or 3 years, I began to realize that even in a general litigation practice, that people start to specialize. And I thought I have the science background. I had worked at Fish and Eve in the summer when I was in law school and decided not to go there at the time because I wanted a broader experience. But I decided if it was time to specialize, then why don't I specialize in something where I really know about the science and in a firm that I like being at.
And how did you go about then? You went to some sort of managing partner and said, you know what, if you have this type of case, I'd like to get involved. How did you do that?
How did I transfer from one firm to another?
No, within the firm, you said, I thought you said within a firm you decided you wanted to specialize and started
No,
to
I had to
specialize.
go to Fish and Eve,
Oh,
then
you
I
had
had to
to,
leave that
oh,
firm.
okay,
Right,
okay, okay. That explains it
right.
then. Fine. Uh, right now, patent law in the United States is not as in the best shape it's ever been in. And this is true and has an effect on actually how many patent lawyers we'll have. So we have what? We have Mayo, we have Alice, we have other things. Is there any hope right now? All right, what is the state of play right now in the United States in your view in patent law in terms of case law?
Well, I think 101 is a very big problem.
I'd explain 101 to the
Okay,
audience.
so that's patentable subject matter. And as a result of the cases that you mentioned, there has been a great deal of difficulty and a lot of decisions invalidating patents on medical diagnostics and also in the technology field and computer technology. And I think that having reviewed the Federal Circuit decisions on computer technology, I think the Federal Circuit has figured out a way to get through this by looking at the relationship between by finding a way to determine that more inventions are patentable and are not within the scope of Alice. I think it's a really big problem in the medical and biotech field, and because the Supreme Court has really declined to take a number of important decisions.
Especially this in Bank Court of Appeals decision that went up, whichever one, they were dying for them to take the
Yes.
case and settle things, and they said, basically, we're washing our hands. We've screwed it up. You guys have to solve
Right,
it.
right. So that leaves us with the legislative route, which is fraught with difficulty. I think if I could step back though, I think what the real problem is in the United States is that when I started practicing patent litigation, the clients that we represented at Fish and Eve, which were the stars of the leading American companies, respected the patent system. Sometimes they were plaintiffs and sometimes they were defendants, but they were not out to destroy the system because fundamentally patents were important to them in the protection of their business. That continues to be true for pharma and biotech. However, the largest technology companies now, such as Google and Amazon and to a certain degree Apple, but not as much because Apple actually enforces its patents. Companies like that have decided they don't like the patent system. They buy patents for defensive purposes, but basically they'd rather get rid of the cost of litigation then use their patents as what we used to call the picket fence model of using the patents to protect your main business. And so as a result, between the legislation that we had in to create the American Invents Act, and the fight now over 101, which pits the technology companies against the pharma companies, we really do not have the same. We have a whole group of very powerful companies who don't really need the patent system and would like to take it down as much as they can.
And will they be successful? Continually be successful?
Well, they're doing a pretty darn good job
Yeah.
right now. I think that I think that there has been some more. I always think that patent law always seeks balance. I mean, we've had some very strong periods of patent protection. We've had very weak periods of patent protection. I think that people are beginning to understand that a lot of companies still do rely on their patents. And if we're going to have a patent system, we have to have one that protects that. But we can't have patent law that's only for one group of companies. It's supposed to be about innovation generally. And I think what the holdup is in Congress over 101 is the very well-financed lobbyists of technology versus pharma are out there duking it out, and that means it's going to be very difficult to resolve it, I think, legislatively.
Yeah, I think basically what you have is a techie community which has a view of technology as God, and anything that gets in the way of technology is a problem. And of course, IP gets in the way of the free use of the technology. And that's fine when techie startups don't care about IP and everything else, and everyone, oh, that's okay and everything. It's like a commune in the 60s where people would share everything and farm and everything else, but they wouldn't go across and the farmer browns and milk his cow. What we have now is techie communes who actually want their rules to apply to everybody so they can go across and the farmer brown and milk his cow. And it's a complete mindset that people have is they don't even understand the other side. If you take the Oracle case, I don't know if you're familiar with that.
I've started to follow it.
Yeah. It's a prime example of people on two sides, 22 amici briefs on Google's side and 30 on, or they're in like different worlds. They're speaking about different things. There's no connection. And that's why that case is so important, because what the Supreme Court does could really affect, and that's copyright, but also IP law in general. So if they affirm the Court of Appeals for the Federal Circuit, which I hope they do, I think Kate O'Malley's opinion is very good, and the Solicitor General wants that. And even the Solicitor General now is seeking to argue on the side of Oracle. They think that's how important they think this is as a case. But it's not like somebody's bad and someone's good. It's just they don't understand the other side. It's like a religion. It's like almost a secular religion, this technology group. And it's very going to be difficult to change their mind on anything. And forget Congress. All you need is one person in the Senate raising a hand, I don't agree to suspension of rules. So it really, to some extent, the Federal Circuit has to get up to the situation. But the problem, I think, and you can tell me differently, because I think the Federal Circuit is fundamentally split now. You have people who actually are comfortable with Mayo and Alice, and then you have people who think it's a disaster, and maybe they are not going to be able to do it. So, what's the solution? One is just take all your stuff and go overseas. Go to Asia, go to Japan, and really just do stuff over there.
Well, I want to scroll back and say that I do think that Mayo and Alice have been interpreted too narrowly. I mean, I don't think the Supreme Court ever said that two-part test is the only test that could ever be used. Okay. I think if you read the opinion, it's actually a lot broader than a lot of people have interpreted it.
I think that I think what happened is, as a non-patent legal realist, is Supreme Court left the Federal Circuit alone for 25 years or something. They safe hands, and then all of a sudden we have biotech, we have software, maybe business method. There's no prior art. We're getting all these bad patents, and it seemed patent bar didn't seem to be looking for ways to solve it, and people screaming bad patents, bad patents. So then the Supreme Court looks to the Federal Circuit, but they split 7-6 in an en banc. So they have to say, okay, maybe we have to do something. So you have there the decision on an injunctions, which makes it used to be you stayed out a case for the patent is valid and everything else, and you got an injunction. Now all of a sudden, that is taken away at least for whatever it is, and I think what they're saying, this was Thomas. Now the irony of this is Thomas is an originalist. So he says actually the judge can determine whether it's an injunction. I think they're saying backdoor the judge can determine whether it's a good patent, and that helps solve the problem. But the trouble with that is, and he's an originalist, and Scalia agreed with it, is Article 1, Section 8, Clause 8 says exclusive right. You can't have an exclusive right if you can't get an injunction, you can't normally get an injunction. But that was not even raised. Normally, they're originalists, you do it. So you see, everything is ad hoc now. We got a problem and sort of solve it, and maybe then we don't solve it. So then you talk about those decisions. Those decisions, I think the court thought were narrow. We're not overruling this. We're not overruling this. We're not overruling this. But some broad language by Breyer or others, other people are either misled or purposely are wanting to have it. And it's kind of I think now the Supreme Court says we started a fire and we can't put it out. And that's why they denied cert, because we'll just inflame more people. So it really is left to Congress or the Federal Circuit, and as we were just discussing, that may not be the best situation.
Well, I think the Federal Circuit has found a way on the technology side.
Okay.
But I think that the problem with the Federal Circuit, not in more recent years, but during the time particularly of Judge Rader and before that the Federal Circuit tends to want bright lines, and the Supreme Court hates bright lines. It says you should have a broad principle of law and apply the facts to it. And so there was a period of time when then the Supreme Court started to take more and more cases. But to compound the problem, a lot of these cases, the Supreme Court can only decide the issue that's brought before them. And I know they can go broader and whatever, but they're kind of really busy now, right? And so what people brief and the issues that they present, the way the issue is framed is so critical to whether you're going to get cert, right? And whether you've got to give them something that they can decide, understanding this is a court that doesn't seem to like to do patent cases. It really doesn't. And several judges, I think, are really openly hostile to the whole concept of patents. So I think that given the number of decisions that they've refused to take on, I think that it's not going to come from the Supreme Court in the near term. I think lawyers could do a lot, better job of interpreting these cases more broadly. Another thing I've suggested, particularly to avoid getting an immediate dismissal on 101 grounds, is to focus on the importance of claim construction, and so making sure that that you have to go through the trial before, at least the claim construction hearing, before you get to 101 issues. So I think that the best option is for lawyers to take as broad a reading of these cases as possible, and to hope that some sanity will prevail in the legislative end. But really, why do we need more legislation? I ask this question. Why don't if we go back to the original language of the statute and we say, and the original Supreme Court cases that say you can't patent a law of nature, why do we really need any more than that? It's not clear to me that we really do.
Well, we may not to, but we have people, well, as you said, we have, I think, people on different sides with agendas where what's important and actually is not process and it's not the law and it's not something else. It's we're gonna, technology is gonna prevail, or pharma, it's not gonna prevail, or the simple thing like bright line rules makes sense for a court because especially when the legislation is so weak, somebody has to be able to know whether they should do something.
Right.
So bright line rules for court created doctrine, it actually makes sense. If everything is ad hoc and I'm a business person, I don't know whether I'm going to invest or not. So I know some people who basically invest and have been investing in patent development and innovation. And now they say they're going to Europe or Asia.
Yes.
So I don't know, it's hard actually to be optimistic. Isn't it? Or am I wrong? Well, you said they've already solved this thing on software.
Yes, and I think they've made that a lot better. I think that also if the Federal Circuit concentrated more on trying to come to agreement between themselves. I mean, part of the problem with the Alice decision was like the 13 decisions of individual appellate judges on the Federal Circuit. I mean, I think the Federal Circuit itself could work on being a little more harmonious and working these things out amongst themselves so different panels didn't produce different results.
Yeah, I mean, it got so that they stopped announcing who the panel was a week ahead of time because people were then focusing on their arguments for that particular panel.
Right.
So everyone recognizes that there's an issue, but for whatever reason, I don't know whether it's personal animosity, I don't know if it's we believe we're right and compromise is bad, or we have people who know patents and people who don't know patents. It used to be, to some degree, the CCPA, Court of Customs and Patent Appeals. Well, it had, some of our stars on it, and then went on to the Federal Circuit in 1982. And there was this view, the Federal Circuit was created, even by liberals, Ted Kennedy and everyone else, is too many patents were being thrown out. And patents were being destroyed by the various circuit courts. And there was a general belief in, I think, patents, and it had to be stabilized. And now, I don't know if there's a general belief in anything in that court.
Well, I think part of the issue, is when you look at the backgrounds of the judges on the various courts of appeals, and I'm going to look at the period before President Trump began to appoint some people to the courts of appeals who had very little experience at all in trials. Most of the judges on other circuits have been district court judges. It's there's other than Judge O'Malley, who on the Federal Circuit has been a district court judge.
Yeah.
And so I think it affects, while they were certainly all trained as lawyers, I think that affects the decision-making process because people feel that they're there, to bring their personal expertise, and background to decide the cases properly. But an appellate court traditionally does try to reach at least some common ground. I mean, imagine what would we do if the Supreme Court started issuing decisions with 7 opinions? I mean, we would go crazy, right? I mean,
Yeah, well, you're right. The advantage of having district court judges on a court of appeals is when they were in the district court, they wanted to be able to ascertain at least what the rules are. and in that sense, bright line rules were a good idea. But at least to have something which they could hang a hat on. Um, and the Federal Circuit judges, almost none of them were even practicing law. A lot of them were just in committees and other things. And so it became a reward to this senator or that senator or something else, and they get and that may be okay if there are enough other people who have the background. But when you don't have enough other people who have the background, you have a court that doesn't seem to be grounded in almost anything. And well, I'm almost going to cry now. It's getting. Yeah, maybe I think it's a little more bleak than you do, but I hope that's something we in the future. My view is just if everyone just follows Polly Newman, we'll be okay. Uh,
Well, I have a more positive view because I still think there's role for good advocacy, and I think that that a lot that there are people in Congress who do want to do the right thing and don't want to get blocked, by particular industry groups, and but come out with a solution that seems fair to everyone. And I do believe that legal systems seek balance, and I really do. And I think that we are having a better trend on certain 101 issues, and I think the PTAP situation is a little bit better, but we have a long way to go.
I think actually there's a lot of good intent in Congress, but I think the mechanisms which were basically created by Southern congressmen who were reelected, they're basically plantation owners and everything, and year after year they're elected. So all the senior people in Congress were from the South, and they created rules which protected the South from messing around with either slavery or Jim Crow laws, or actually they are not commercial, and rather that they could block tariffs which are going to hurt their sales or other stuff. So they created a mechanism, and now the Senate has something where one person just says, I object, can hold up things. And any law that comes onto the floor, they have to have unanimous consent. That the rules which say you can debate for a week or weeks can be restricted to 2 or 3 things. There's so many mechanisms created so the minority could stop legislation they don't want. And now, like American Vent Acts, that wasn't ready to go out. We did it every year at the Fordham Conference, and not ready, not ready, not ready. That came out, surprised everybody, because Congress was being criticized as not being worried about the economy, and not, this is a while back, and not even being able, it was partisan, not being able to. So all of a sudden they pulled it out and passed it. And if you look at the press release and the press conference, they treated it as a jobs law.
Right.
They didn't even mention patents. So that was basically used, not because of patent policy or anything else. They took something that wasn't finished, but for another purpose. So the one big thing they've done wasn't even completely ready, which they usually are, what the industry agrees on it on both sides. So I hope you're right that I think Congress, even when it has good intent, it's difficult to get things through. So
I think what would be beneficial here, I think if Congress, I'm not as familiar with the rules of the Senate as you are, but I think what we're lacking in Congress these days for important legislation is hearings in which different people from different industries come in and testify. Now, there have been hearings, at least on 101 in this committee, not the full Congress, but that's what was missing in the American Invents Act. There was no congressional testimony on that. There was no hearing of different sides and trying to figure out. You could have, some of that legislation could have used some improvement. You could have still have had it and certainly made it better. But what I think Congress needs to do is to actually hear from experts on both sides in all industries, because just like you don't want to harm any particular industry, but you shouldn't harm other industries because of one industry. And so something has to be done that is really industry neutral with respect to 101. And that's going to be hard, but it could be done.
So in the meantime, you're a lawyer for a client. What is your, and let's say it's a pharma client. What do you tell that client about what to do with a new invention they're thinking of? Just go about it normally, and we'll do the best we can.
Well, first of all, they should get patents, and
Oh
and
yeah, yeah.
everywhere, right? But well, in terms of depends on what type of pharma. Obviously, drugs are don't have a 101 problem. But I have to say that I have some advised some clients, particularly clients not located in the United States, to not sue in the United States. That was a couple of years ago. I think I might be a little more bullish now, and to sue in Europe. And I think that that is why I think that any major legislative initiative has to include litigation in Europe on
Okay,
a
how do you,
faster track than
when you say Europe, of course you have all the different countries. You can pick
right.
um, how does a client pick what? I mean, I know in patents most people like Germany
Uh,
because you you get an injunction early, you don't even get to whether it's a
right,
valid patent.
right,
That's a separate proceeding. So they have
right.
bifurcation. Is that the advice you would give, that all things being equal, sue in Germany?
Well, I think you would also sue. I think it's a balance. You want to sue in any major market where it's important. Okay, so that means suing in more than Germany. However, you then have to look at the current state of affairs, which constantly keeps changing, as to where you're going to get to trial first. Because, in my experience, even in the United States, between competing litigations, the case that gets to trial first drives settlement.
In case what?
The case that gets to trial first drives settlement. Okay, if the case is going to be settled, it will be that first case to trial that will most likely to provoke it, and who's ever got the upper hand in that litigation has the upper hand in settlement.
So, uh, using that theory, would you say Germany?
Well, currently I would say Germany, but I don't. Some people say the Netherlands because of the port that's there. I mean, I would want to pick among several jurisdictions, understanding what the laws are about validity and in these countries. I mean, there are some patents, that could the counterparts that could sustain a validity attack better in some jurisdictions than others. But Germany is always going to come out, if not at the top of the list, close to the top of the list.
Yeah. Well, you certainly want to have a country where whatever they decide, other judges in other countries are going to think twice before they rule differently than that.
I'm not so sure about that, but yeah.
Um, all right. Do you have any examples of that?
About whether judges in one country are going to pay
Well, if
attention
I'm
to
a
the
judge
ruling
in
in
this
it.
country and I'm the first, then I have, whatever I do, people can say it's right or wrong. But if and you're talking about major jurisdiction, has already said this is the result. If I'm going to go against that, I may be less inclined than if there's no precedent. In other words, I think
In the
among
United States, that would be true.
but among judges, I've found because of the conference and everything, they know what everything is going on, and I think
Yeah.
there's a feeling of, I don't know, more effect on one another on what they're doing, or not. Maybe I'm wrong. But your theory, let's say you would then sue in three major places at the same time.
Or maybe more than that. I would certainly consider um, Germany. I would consider the United Kingdom. I would consider the Netherlands. Um, I would consider South Korea and or Japan. I mean, these were all, but usually, I think that probably somewhere between, one should think about somewhere between 2 to 5 jurisdictions to start out with. But I don't. The thing is that what you don't want to have is to bring 4 cases and then be sued in 4 other places that you didn't sue in. So if it's really a big case, you should take a preemptive strike and sue maybe in 10 places, all the places to protect your business so that there's not a basis for you to be sued in other jurisdictions, because then it gets crazy. You've brought 5 cases where you're the plaintiff, the other side's brought 5 cases where they're the plaintiff. So I think if you think there's a real risk of being sued somewhere, you also have to put that on the list.
Okay. Final thought is, what are the challenges facing women today, and generally in law, but specifically in technical and patent litigation?
Well, I think that the challenges placing women in technical and patent litigation are not that much different now from the ones that are being faced in general litigation. And there is still, because so many women, it used to be when I graduated with a degree in chemistry, most women did not have a hard science degree. They tended towards biology. Now we have women electrical engineers and whatever. I think that problem is behind us. But I recalled in the article I wrote in 2011, I went to hear a group of judges from the Appellate Division, First Department in New York, talk about where are the women, pointing out how few cases before them women were lead counsel or had argued an appeal. I think at that time it was for 98 commercial cases, only 12 cases had women. I just went in February, earlier this month, to a diversity program on becoming an ally with judges, again, from this time from the Southern District, the Supreme Court, and the First Department. There's been no real improvement over the course of time in terms of women arguing cases, important commercial cases. And I think that continues to be a problem. And I think it continues to be a problem about how people treat or the opportunities and treatment of young women who are mothers. I think that's still a challenge.
All right, so how can you treat young women who are mothers better to alleviate this problem?
Well, I think you first of all have to respect the fact if they are part-time and they have to leave at 5 o'clock, you have to let them leave at 5 o'clock. And you can't create a crisis at 4:30 every day to stop them from leaving. And that may affect the type of cases that they have. So you put them on a case where you can accommodate that, where there are other lawyers on the case. And, sometimes women, want to do, like good lawyers, everywhere they want to do as much as they can, but you have to respect it and find the right work for them during that period, and don't assume that it has to be the worst work on a case. This and I think otherwise people have to make more of an affirmative effort to get women into the courtroom, and that obligation relies on lead counsel.
Now, do you think is part of this that some women don't want to be in a courtroom, or are you saying that women want to be in a courtroom and are being stopped from being in a courtroom?
It's the latter. They want to
Oh.
be in the courtroom, and they're not being put there.
When I was coming out of law school and I was in the U.S. Attorney's Office, we had women uh, who were in there the same with me in baby crimes and everything else, who were fantastic and successful, and then they went out and were successful in practice. Now, I don't, maybe that's because that whole experience of trying cases all the time then makes it easier to continue to do that
Yeah.
the rest of your life. But if you don't have that, it's difficult. So what about going into U.S. Attorney's office or the DA's office or something earlier on, Would you advise some women to do that as a way to?
That is, I mean, that's been a traditional way that men have used. I think particularly now because there are so few opportunities to argue, to go to trial now. I mean, that's generally true across all litigation. That would be a good opportunity. But still, even when they get to the law firm, somebody has to make sure that they get out in front of the judge.
Okay. All right. Well, Pat, thank you very much. It's been fantastic. I think you have an amazing career, and I recommend we're going to give the two sites to these two articles that I really think everyone should read. And so, what is the future for Pat Martone in the law? I mean, you have your own firm. Um, are you going to expand the arbitration? You're going to expand the client contact? Are you going to, what are you
Well,
going to?
I think I'm going to do arbitration, and I'm also thinking about writing a book or maybe two different books, and that's what I think is next for me.
Whoa, hold on. Give us a little preview.
Okay. The one book I would like to write is about creativity and the enormous creativity I have seen, in the clients that I've worked with, and which fascinates me because I'm also interested in art, for example, and you see this creative spark in people. It comes out in different fields. It comes out in art and fashion and science and whatever, and just observing people's work, inventors' work, and how they did what they did to me is a constant source of amazement. And that's one of the things I would like to write about.
Okay. What's the
The
second?
second is really to write more about my career path, as because I was the first to do some things, and I think that would be worthwhile.
Yeah, I think it'd be worthwhile as well. Well, you've had an amazing career and you have a lot to say that would be good for everyone. And a book certainly would be a way to do it. And also, everybody should just tell everybody in the world that this podcast is crucial in many ways, and they should all listen to it. But anyway, thanks, Pat, so much.
Oh,
This was
thank
great.
you. It was really a pleasure to
All
be
right.
here.